I'm Kevin Carnes. As your lead clerk and comptroller, I'm committed to ensuring you have helpful and easy to access service from the clerk's office. This how-to seminar is designed to assist you in navigating your court services and Lee County's official records. You can attend these sessions in person or view them online at leeclerk.org. I hope this convenient service enhances your customer experience with my office.
Hello, and welcome to your Lee County Clerk of Court and Comptroller's Office how-to seminar on filing and responding to an eviction case. My name is Yesenia Williams. I am the Community Relations Manager for your Lee County Clerk of Court and Comptroller's Office, and I'm delighted to go over this information with you today. A brief overview of our seminar. We're going to talk a little bit about some general eviction information, including landlord and tenant rights and responsibilities. Then we'll have an overview of the eviction process, including how to evict a tenant, how to respond to an eviction as a tenant, the related fees associated with filing for and responding to an eviction, and some available resources and contacts for you. The Clerk's Courts Department is who assists with filing and responding to eviction cases. Our main office, located at 2075 Martin Luther King Jr. Boulevard, the Lee County Justice Center, which is pictured here to your left. Our customer service counters are located on both the first and second floor of that building. The first floor is for assistance related to criminal cases and matters such as traffic tickets, misdemeanor cases and felony cases, as well as filing injunctions for protection. On the second floor is where you can see us for circuit civil, county civil, or family matters, such as filing or responding to an eviction case. We do have a satellite office in Cape Coral located at 1039 Southeast 9th Place on the second floor of that building. We offer limited services at that office at this time. Filing and responding to an eviction case is one of those services. So if you're a Cape Coral resident, we encourage you to visit us there. Our contact number is 533-5000. And the Clerk's Courts Department serves as clerk to the courts. We are the official record keeper for the courts. We also complete all of case processing from the moment a case is initiated to when it is closed. And we provide court financial assessments and support. So before we get started on the actual process of filing and responding to an eviction case, just some general information. A residential landlord-tenant action. This applies to the rental of a non-commercial dwelling with or without a rental agreement. It involves an action that's filed by a homeowner against a tenant for common disputes dealing with payment of rent or non-compliance, or a breach of a lease or a rental agreement. Lee County does require that the homeowner be referenced as the plaintiff when filing for an eviction case. While some of the forms may read landlord, you do want to make sure that the homeowner is who is referenced as the plaintiff. If you do have a commercial, agricultural, or personal property lease, we do suggest you consult an attorney. The forms and information provided in this seminar will be strictly for residential tenant evictions for non-payment of rent. Pursuant to Florida statutes referenced here, 454.18 and 28.215, Florida law does prohibit the clerk's office from assisting with the management of your case or advising or instructing a party in filing a case for tenant evictions. So if you are in need of any legal advice or counseling, we do encourage you to contact an attorney. Some landlord rights and responsibilities, and this is as outlined by the Florida Department of Agricultural and Consumer Services. So some rights include receiving rent, re-entry to the property, and return of the premises without damage other than normal wear and tear. Some landlord responsibilities include maintenance, compliance with codes, extermination, clean and safe common areas, as well as functional water and heat. Some tenant rights and responsibilities include rights as fair treatment, peaceful use and enjoyment of the property, and a habitable residence. And some tenant responsibilities include maintenance of the property and paying rent when rent is due. So when it comes to the termination of a rental agreement, this can happen several ways. So one, it can happen when a tenant abandons or surrenders the property. And it can also happen if the time agreed upon in the rental agreement has expired. So if you have a 1-year lease and that 1 year has expired, then that rental agreement is considered terminated. Or in the case of an eviction. And this again happens if a landlord is seeking to terminate the agreement due to noncompliance with terms of the agreement or non-payment of rent. So possession and damages is what we're going to go over. And possession of the property and damages are not physical damages to the property, but it is rent owed. When I refer to damages, I am referring to rent that is owed or back pay of rent. So this eviction can occur if there's failure to pay rent, or again, if there's non-compliance with other terms of the rental agreement. If there are and the landlord wants to move forward with the eviction process, then they need to decide if they want to sue only to regain the possession of the property, or if they also want to request damages, which again is back pay rent. So a case for an eviction and for damages can proceed simultaneously at the same time, but requesting damages will involve some additional forms and requirements, which we'll go over a little later in the presentation. But before moving forward, again, the landlord needs to decide if they want to sue for just regaining possession of the property or possession of the property as well as damages, which again, damages means back pay rent. So a basic overview of the eviction process, just a visual here for you. It starts with, and I will be going over each one of these individually. It starts with a 3 or a 7-day notice. From there, it goes into the initial court filing, the service of the summons, an answer or a default, final judgment, and writ of possession. And again, we will be going over each one of these steps individually. So the first step is a notice from the landlord to the tenant. So this must happen first before moving forward with a court case being initiated. The landlord must provide notice of the eviction to pay rent due or vacate the premises to the tenant. The 3-day notice is a notice from the landlord to the tenant for termination for failure to pay rent. The 7-day notice pertains to non-compliance for matters other than failure to pay rent. So if it's non-compliance strictly because rent has not been paid, then they are required to provide a 3-day notice. If it is an issue other than failure to pay rent, they are required to provide a 7-day notice. So a template of this notice is available on the Florida Bar's website, and it can also be accessed by viewing our residential non-payment of rent checklist on our website. This notice, once the landlord is ready to provide the notice to the tenant, it can be posted on the premises, hand-delivered, or mailed. It does not need to be one or the other. It could be any one of those. It does not need to be hand-delivered. This notice does not include the day of delivery, weekends, or holidays. And for the purpose of this presentation, we will be focusing on the 3-day notice as we are focusing on failure to pay rent. And this is an example of what that notice looks like. The landlord, again, is advising the tenant that they must pay the debt or vacate the premises by the date that they've outlined on this notice. And the notice, the date, again, will exclude the day of delivery, any holidays, or any weekends. So once the tenant receives this notice, they have 3 different options. The first option is paying that past due rent in full. Florida law does allow the landlord to refuse partial payments. However, if a landlord does decide to accept partial payments, they must then give a new 3-day notice with a new amount owed to the tenant. So that's the first option. They can pay this past due rent. The second option is to vacate the property. The third option is to do nothing. So if the tenant does nothing, at this point, the landlord may then commence an eviction court case by filing the formal documentations with the courts. So if that's the next step that the landlord is wishing to take, these are the required forms for filing. Again, we're focusing on possession for the purpose of this presentation. The first form is a civil cover sheet, and these forms are all linked on our website. The next form is a complaint for eviction, or if you're seeking eviction and damages, again, that means back pay rent as well. So you would have to do one or the other. A copy of that notice that was given to the tenant, that 3-day notice, must be attached to the complaint. So when you are ready to file, you must attach that notice saying that you did provide that notice to the tenant in addition to filing the complaint. The next required form is an affidavit of ownership and notice to parties. This is proof that the plaintiff does own the home. An affidavit is considered a sworn statement, which means that this document will be need to be notarized. Our office does offer notary services for a nominal fee, or you can have the form notarized elsewhere. The next document is an affidavit of owner and consent. This is only required if the property manager or the person filing is not the actual owner. So this is again a sworn statement stating that they are able to file on behalf of the actual owner. And finally, the summons is also needed. Step 3 is a service of a summons. So each tenant requires service of both the complaint and the summons. So once you come to us to file all of the paperwork, you have all of the forms ready, what we'll do, the clerk's office will prepare 2 what's called service packets for each of the tenants. One of those service packets will be sent by the clerk's office via mail to the tenants. The other service packet will be given to the plaintiff in order to facilitate service. And we're going to go over how to facilitate service in the next slide. So when you are delivering in person or via mail, the plaintiff must provide the original complaint and all supporting documents, plus 2 copies of what I just mentioned per defendant. This, for example, if you have 5 tenants, you're going to need to make 10 copies. And we do have a very thorough checklist available on our website that'll help you understand how many copies you're going to need depending on how many tenants you have. We'll also assist you with this process if you come and see us in person. So once you're ready to initiate the service, there's 2 ways that you can do that. You can either visit the Lee County Sheriff's Office to facilitate that on your behalf. They are located at 2072 Victoria Avenue in Fort Myers. Their contact number is 477-1353. They do have a service fee of $40 per tenant, and this money would be made payable to the Lee County Sheriff's Office. You can also go through a process server. Process servers are private entities, so you would have to do your own research in order to find a process server, and their fees are determined by themselves. So if you are also seeking, in addition to the eviction or possession, you're also seeking damages, this means that this individual must be personally served. So you still have to go through either a process server or the sheriff's office to facilitate the service. But if you're only seeking eviction, they can just serve the individual by posting the documents or on their door. But if you are also seeking damages or back pay rent, the individual must be personally served by either a process server or the Lee County Sheriff's Office. So step 4 is now the tenant must respond if they have been served with the formal documentation for a court proceeding eviction case. So when it comes to a time frame, if the eviction is only for possession, The tenant has 5 days from the date of service to respond, and these are 5 days not including that actual date of service where they were served, weekends or holidays. If they are being sued for damages in addition to, then they have 20 days from the date of service, again, not including the date of service, weekends, or holidays. The tenant will have until 5 p.m. if they are responding in person on the last day to file a response with the clerk's office. In other words, do what the summons is telling them to do. If they respond electronically, then you have until 11:59 p.m. to respond on that last day to the court case. And I'll go over the electronic filing portion later in the presentation. If the eviction is for failure to pay rent, Florida law does require the tenant to pay the amount that is alleged on the complaint into what's called a court registry. So in addition to responding within 5 days, you also need to deposit that rent amount into the court registry with the clerk's office within those 5 days as well. We do have a blank response form available on our website in order to respond to your to the eviction case. We also have it available in person in our customer service lobbies and self-help room. This is what the, when it comes to the tenant's response, this is what the summons will look like. As the tenant, once you have done all of the things that are required of you, which would be all of the things that are outlined on the summons, the landlord is now responsible for the next steps. And just some examples is giving the clerk the rent, the court clerk the rent that is due, and writing down the reasons. If you feel that you should not be forced to move, you would have to outline those reasons. But once you respond, it is on the judiciary side to review your response and then next steps. So the next step would be the judgment. If the tenant does file an answer, and if applicable, if they do pay into the court registry, what the judge will do is review the case file and determine if a hearing is needed. If a hearing is set, the court will notify all of the parties by emailing them or through regular mail. The plaintiff is then responsible for bringing a proposed final judgment to the actual hearing. If the tenant does not file a response or an answer within the time that has been allotted to them, and or they do not pay the unpaid rent into the court registry within the 5 days, the landlord may then request what's called a default judgment. In order to request a default judgment, they do need to file the following forms. And again, these are linked on our website. They would need to file a motion for clerk's default for a residential eviction, a motion for default final judgment for a residential eviction, a proposed final judgment for eviction, and this would also need to come with self-addressed stamped envelopes, one for the plaintiff and one per defendant or per tenant. And some judges do require what's called a non-military affidavit form. Once the plaintiff, the landlord, files these forms because they are requesting a default judgment, it is up to the judge's office on what the next steps will be. If a final judgment is entered by the court, so the landlord filed the forms I just mentioned and the judge's office did enter a final judgment, and the tenant refuses to vacate the premises, then the landlord can seek what's called a writ of possession. So in order to obtain a writ of possession, they will come see the clerk's office in the Lee County Justice Center on the 2nd floor requesting a writ of possession. We will then issue the writ of possession. Again, we cannot issue the writ until the judge signs the final judgment. So this is only if the judge has entered a final judgment. The writ will then be issued and given to the landlord, and they will need to go to the Lee County Sheriff's Office to actually have that writ executed. The sheriff's office at this time does charge a $90 service fee, again, made payable to them in order to execute that writ of possession. And that writ will instruct the sheriff's office to remove the tenant from the property. The sheriff will first post a notice on the property, giving the tenants 24 hours to vacate the premises. So that essentially finalizes the process that's associated with the eviction, the residential evictions for non-payment of rent. So we're now going to go over what the fees that are associated with landlord-tenant eviction. So for a landlord-tenant eviction, you're looking at a $185 filing fee, and that will need to be paid at the time you file the appropriate forms to initiate the case. There is an additional charge for defendants over 5. So if there are over 5 defendants or tenants, it would be an additional $2.50 per tenant or defendant. There is a $10 fee to issue the summons, and this is each summons that's issued. So if you have 2 tenants, you will need to pay 2 $10 fees to have the summons issued, because there does need to be 2 different summonses. We do offer notary services. At this time, it's $10 per signature. And if you recall, I mentioned that you may be required to deposit rent, past due rent, into the court registry. There are fees associated with paying into the court registry. It is 3% for the first $500 and 1.5% for each $100 over that $500. And we do have a calculator that calculates that exact fee that would need to be paid. So if your past due rent amount is $1,500, you will have to pay that $1,500 in certified funds, meaning a cashier's check, cash, or money order. In addition to that, you will also have to pay the registry fees, which would be 3% for that first $500 and then 1.5% for that $100, each $100 over that $500. And that registry fee can be paid. It doesn't need to be certified funds, so it could be a personal check, a credit card, a debit card. What would need to be a certified fund is that actual past due rent payment that will go into the court registry. I do want to note that fees are subject to change, so I encourage you to visit our website at leeclerk.org/fees for the most up-to-date information regarding fees. So in addition to filing in person or through the mail, you are also able to file online. You can file your eviction case and respond to your eviction case electronically. This is available to you 24/7 via the Florida Courts e-filing portal. You can visit the e-filing portal at myflcourtaccess.com. You can download, what you would need to do is download the forms, still the same exact forms that I mentioned throughout the presentation, from our online forms library. You would fill out the forms either by filling them through electronic PDF, or you can download the forms and handwrite on them and then upload them into the portal. You can, the Florida Courts e-portal, the only difference in comparison to filing in person is completing the mailing. So we do have a certificate of mailing in our forms library. You're also able to print and upload that document as well. But it will walk you through the entirety of the process when you do decide to electronically file, if that is the method that you choose to file. So I do want to mention some other eviction related matters that, while we do not have the forms and cannot assist you with these, you will need to, procedurally, we cannot assist you with these. You will need to perform your own legal research or consult an attorney if these situations are something that you are going through. We have some basic information regarding unlawful detainers on our website, but we do not have anything as in-depth as we do for residential non-payment of rent. So an unlawful detainer, this is if there is no landlord-tenant agreement or periodic rent. Once there was consent and consent has been withdrawn, and it can be brought by either the landlord or a lawful tenant. The other kind of eviction-related matter is what's called an ejectment. This is if a petitioner owns the property and someone that does not have a landlord-tenant relationship with the petitioner refuses to leave and also claims they have right to possession or title. Again, if these are situations that you are having challenges with or need more information on, then you will need to either perform your own legal research or consult an attorney. Some quick contacts and resources for you. We do partner with the Lee County Legal Aid Society in facilitating some free consultations, or you can call them directly by calling 334-6118, visiting their website at leecountylegalaid.org. We do have a self-help center located in the Lee County Justice Center on the first floor. We have a complete forms library available there for you for not just eviction cases, but other cases as well, including small claims and civil injunctions for protection. We have computers where you can print, perform legal research, and we also have a special role, special to Lee County, called a Justice Navigator. Our Justice Navigators are there to do just that, help you navigate the complexities of the judicial system. Of course, we cannot provide you with any legal advice, but we can assist you procedurally. The Lee County Courts Department can be reached by calling 533-5000 or emailing courts@leeclerk.org, and one of our customer service specialists can assist you with your questions regarding your filing. Also visit our website at leeclerk.org/evictions, where you can find our residential non-payment of rent checklist that breaks down the process for you as well. And if you need assistance, there's also the United Way 211 helpline. We encourage you to call the 211 helpline. We are aware that they can assist with potentially assisting with rent or home or housing issues. So we encourage you to contact them as well. This is just an example of what that checklist I mentioned looks like. It does break down the steps, as you can see on your left-hand side. Tells you what forms you need and for what, and where the forms can be found. And then when it comes to copy and envelope requirements, it also breaks that down for you at the bottom. So I encourage you to look at this checklist to help you with this process. And that concludes our presentation here today. Please visit our website at leeclerk.org/subscribe, or scan this QR code in order to connect with us and subscribe to our newsletter so you can be notified of the latest events and seminars going on with your Lee County Clerk's Office. If you have any specific questions or suggestions, please call me at 533-2763. That is my direct line. If I do not answer, because I am in and out of the office a lot, please leave me a voicemail and I'll make sure to get back to you to assist in the best way I can. Or you can email me at ywilliams@leeclerk.org. Again, I'm Yesenia Williams. Thank you for watching.